The road to winning Social Security disability benefits can be long and difficult. Typically, that road includes a hearing before an administrative law judge. And usually administrative law judges ask a particular expert to be a part of the hearing, referred to as a vocational expert. Now, there's a lot of confusion about vocational experts. Just who are they? What is their role in your disability hearing? Well, today on Disability Matters, we'll discuss vocational experts and what their role is in your disability case and address any concerns that you may have. Hi, this is Dallas Disability Attorney Stan Denman, and this is Disability Matters, a YouTube channel dedicated to the process of winning Social Security disability benefits and not going crazy in the process. If this is a subject that's of interest to you, I hope that you will click the subscribe button below so that you can be notified of new content when it drops. Today we're going to be talking about vocational experts and their role in Social Security disability hearings. Now, when I first started doing Social Security disability work more than 25 years ago, it was very rare for there to be vocational experts in administrative law judge hearings. That is no longer the case. In fact, it is the norm to have a vocational expert testifying in your disability hearing. Now, in spite of the prevalence of vocational experts, the government doesn't do a very good job of informing people just what the role of the vocational expert is. Typically, folks are first aware of a vocational expert when they get the notice of their hearing, and in that notice there will be a copy of the letter sent to the vocational expert inviting them to come testify. There will also be a very cryptic statement that says a vocational expert will testify in your hearing. Is there any wonder folks are alarmed and vaguely disquieted when they see that? Oftentimes people think this is someone that's going to be testifying against them, that's going to be working to deny their claim, or is going to be a decision maker in their case. Let's talk about just exactly what vocational experts are in hearings to do. First of all, let's talk about who they are. These are folks that have been trained in vocational rehabilitation, job placement, technical training, and assessing the job market. Oftentimes they are folks that have worked for the Disability Determination Service. This is a state agency. There's one in every state. There's one in Texas that assists people who have a disability or a limitation in job training and vocational rehabilitation. They don't work for the government. They're usually private contractors. They have other work, but typically vocational experts do receive the bulk of their work from Social Security disability hearings. So there are three primary roles the vocational expert has in your disability hearing. The vocational expert is present in the hearing to serve as a resource to the administrative law judge. That person is not there to be a part of the decision making. The decision as to whether or not you are disabled is solely a decision that the administrative law judge will make. The vocational expert is simply there to be a resource for the administrative law judge. There are three primary uses of vocational experts in disability hearings. The first is that the administrative law judge will look to the vocational expert for testimony about the type of work that you've done in the last 15 years, what's referred to as past relevant work. The judge is interested in hearing from the VE what are the functional demands of that work. What was the work setting? What type of preparation was required for that work? Now, it may seem a little silly that the judge would be looking to somebody else for that information other than you, because you're the one that did the work. Obviously, you know the functional demands of your past work. But Social Security disability can deny your disability claim based upon an ability to return to past relevant work in two ways. One, they can determine that you are able to return to the work as you actually performed it. But they also can turn you down if they determine that you could return to the type of work that you did as it was performed in the national economy. That's primarily where the vocational expert comes into play. Vocational expert will testify about how a particular job is performed in the economy and what the functional demands of that work would be. For example, let's say you had a job as a cashier for 15 years in a small grocery store in which you both served as a cashier and you also had to stock shelves when customers weren't at your station. You have a bad back and you're unable to do much lifting. The judge could turn you down not based upon your inability to do the stocking, but on the basis that that judge might determine you could go back and be a cashier as it's performed in the national economy, which does not require specific lifting. A second reason an administrative law judge may ask a vocational expert to testify in your hearing is in order to determine whether in your past relevant work you acquired skills that could be taken to other work, what is referred to as transferable skills. All right, reason number 3. We've come to the most important reason that administrative law judges ask vocational experts to testify at disability hearings. The judge wants to know what are the vocational implications of the functional limitations that you have. So by far the most important reason administrative law judges call vocational experts to testify in disability hearings is because they want testimony as to the implications of your functional problems. What do they mean as far as your ability to work? What work limitations do you have, and what do they mean as far as your ability to do what you used to do as well as do any other kind of work? Now, the way in which the administrative law judge secures this testimony is kind of odd. It's via what are referred to as hypothetical questions. This is an area that is understandably confusing to a lot of people. The judge will pose a series of hypothetical questions to the vocational expert that paint a picture of a hypothetical person that has characteristics that are identical to yours in terms of age, education, and work background. The administrative law judge will pose a series of questions. He or she will not put all of your limitations into one giant question. Rather, the practice is that the administrative law judge will first ask a hypothetical question and include the limitations that were found by the disability determination services at an earlier stage in your case. In other words, when you were turned down, the government earlier found you had a specific functional limitation. And just as a precaution, the administrative law judge will go ahead and ask a question with those limitations. And of course, usually the answer is, here are jobs that could be done. After all, that's because Social Security denied you originally, so it's not surprising that there's confirmation of that. But the administrative judge will then move on to different scenarios, different restrictions. In a sense, he or she is building the questions, building the profile, until he or she gets to a point where essentially the limitations are so extensive that the vocational expert is expected to testify that there are simply no jobs a person with that profile could have. Now, in the old days, administrative law judges did telegraph what they were thinking in terms of their vocational questions. For example, oftentimes when an administrative law judge was clearly going to deny a case, he or she would simply stop the hypothetical questions and never get to hypothetical questions that would result in testimony that there were no jobs. And on the other side, it was oftentimes a signal when the administrative law judge put a lot of restrictions in the question that he or she was indeed going to pay this case. But it's no longer the case now. The training seems to be that the administrative law judges are trained to pose hypothetical questions from least restrictive to most restrictive. This is an area that gets people confused. I get phone calls all the time from people that have been denied at a disability case, saying, in a disability hearing, saying, but the vocational expert said there were no jobs that I could do. That doesn't mean that the administrative law judge is going to approve the case. In other words, the hypothetical questions are a way in which the administrative law judge lays out what each restriction would mean for you. What is the point at which you are indeed unemployable? But always remember the decision as far as what limitations are indeed credible. That's within the administrative law judge's purview. So a judge can simply pose a question that results in no jobs being available, even though he doesn't necessarily think that that restriction is real. Make sense? Well, thank you for listening to this episode of Disability Matters. I hope this segment has helped you in understanding the role of vocational experts in disability hearings. If you have any questions, please leave them below. I will get to those as I can. And if you have any comments, if you have any experiences with vocational experts in disability hearings, I'd love to hear from you. It would be helpful to me, and it'd be helpful to the group as well. Thank you very much for your time.